Hello, my name is Marc Firestone and I thank you for tuning in to this video. I'm going to spend a few minutes to give you an overview of US and European, specifically EU, competition law. By way of introduction, I'm an adjunct professor at New York Law School in New York and also general counsel of Philip Morris International in Switzerland. I'm going to be speaking on my own behalf, not on behalf of PMI or New York Law School. Also, I'd like to note that I'm really going to be simply providing a few highlights, a general introduction to these very interesting but sometimes quite complicated topics. Moreover, I'm going to focus on the jurisprudence of the United States Supreme Court and the European Court of Justice. There is a huge literature of commentary regarding competition law, and there are many areas that are unsettled or the subject of controversy. So again, I'm simply going to try to give what I would call a neutral view by drawing on the high courts in the United States and in Europe. So with that, let me begin with the origins of competition law, or as in America the term is antitrust law. And with that, a very brief note on terminology. In Europe and in the European Union system, the term competition law is more common than antitrust. But in reality, even in the EU, we often see the term antitrust, and it's essentially a subset of competition law. Competition law includes many things, including the European doctrine of state aid. Antitrust is essentially a subset, and from time to time I may use the terms antitrust and competition law synonymously. Now, the origins of modern antitrust or competition law are essentially American. By essentially, I want to emphasize that for centuries, in both common law and civil law systems, there have been many principles that govern free and fair competition. But what we're talking about on this video, when we discuss antitrust or competition law, we're really talking about laws that took shape in the late 19th century and have really fully developed over the last 100 or so years. In the United States, after the Civil War, which ended in 1865, there were tremendous social changes, and those social changes included tremendous changes in economy, in business, in the way of doing business. In the 1870s, in the 1880s, there was first a tremendous geographic expansion as the territory of the United States increasingly moved west past the Mississippi, past the Missouri, all the way to California. And that western expansion entailed enormous changes in the economic conditions that I'll mention in a minute. Related to that geographic expansion in many ways were changes in the way of doing business. In the early 1800s, for example, most business was on a very small local basis. A business might be a partnership of 3 or 4 people. It might serve customers in a sphere of maybe 50 or so kilometers. But as geographic expansion took place, as pioneers and so on moved westward, the geographic scope of business expanded. And much of that geographic expansion related to railroads. in 1866, there was the completion of the Transcontinental Railway, which linked the railroads from the East Coast all the way to the West Coast. And here's where we see one of many, many interrelationships with changes in the nature of business. To build a railway or to engage in other large infrastructure projects required large sources of capital. And an emerging way in the second half of the 19th century to raise capital, to raise funds, was by issuing stock to the public. And so, although corporations, as a legal form of doing business, had existed for hundreds of years, this was really the dawn of corporations as vehicles to raise large amounts of capital. Put simply, corporations began to issue shares in themselves in exchange for cash, and the corporation was able to aggregate and then use that cash to fund major capital or infrastructure projects. There were also developments in the forms of new energy sources, primarily petroleum. In, say, the early 1800s, forms of lighting with oil came not so much from petroleum oil, i.e. that was pulled from the ground, but often from, say, whale oil. But in the 1860s, 70s, and 80s, there was more and more extraction of oil from the ground, and then that oil led to improvements in refining of the oil, new forms of oil, and oil usage and products such as kerosene. Now, there was a significant interconnection between railroads and oil, in that to move oil from the fields of extraction, from the oil fields, say in western Pennsylvania, to the railheads in eastern Pennsylvania or Maryland, required an efficient form of transportation. Now, obviously, at this time, there were no oil tankers that ran by truck over ground, but instead there was the possibility of transporting oil by rail. And so as oil extraction increased in volume, there was greater and greater need for rail transportation of that oil. So already we've identified two emerging and fast-growing industries in the second half of the 19th century in America. One, the railroad; two, oil, which were, in a sense, interrelated. And a third industry, easy to imagine, is steel, because to build a railroad obviously requires steel to make the rails for the railroad. And steel, of course, was a third major heavy industry, capital intensive, that grew during the second half of the 19th century. Now, you might be wondering, what does all of this have to do with competition law in 2017? Well, in fact, all of that has a lot to do with competition law in 2017. Because along with the growth of these industries, as well as others, there was a phenomenon in the United States called the concentration of wealth. Now, obviously, for decades, if not centuries, there had been people and families in the U.S. who were very, very wealthy. But what was perhaps somewhat different in the second half of the 19th century was the size of wealth that people were accumulating, that individuals were accumulating, but equally that people were accumulating through the form of corporations and stock issuing corporations and through different ways of doing business through corporations. And a lot of the attention focused on one particular sector and, frankly, one particular individual. And the sector of focus in the 1870s and 80s, and I say focus, one could actually say the focus of controversy, was the oil extraction and refining industry. And the person most closely associated was John D. Rockefeller. Now, John D. Rockefeller started out quite poor, but began a business of extracting oil in Ohio, and through his energy, his entrepreneurship, his vision, but also through the way he conducted business, which was the subject of enormous controversy and criticism, he was able to build an enormous enterprise called the Standard Oil Company, or as was often said in shorthand, the Standard. At one point, Rockefeller controlled roughly 90% of the oil extraction in the United States and much of oil refining as well as oil pipelines, which were a form of transportation along with railroads. But Rockefeller also transported much of his oil along railroads, and he was able to use his market power, i.e. the percentage of oil that he controlled, to negotiate, or some would say force on railroads, very favorable tariffs for transporting his oil. Smaller oil companies that could not offer the volume of oil that Rockefeller could offer to railroads were at a competitive disadvantage relative to Rockefeller and the Standard Oil Company. And of course, Rockefeller had many, many other advantages by virtue of the size of his holdings relative not only to Rockefeller's customers for, say, transportation and purchase, but also competitors against him in oil extraction, oil refining, and oil transportation, whether through pipelines or over railroads. So Rockefeller created an enormous concentration of wealth, of economic power, and many said of political power. There were certain state laws that existed at the time that people sought to use to challenge Rockefeller's activities, but those challenges were largely ineffective. And desire grew to have a federal statute, a federal law, not common law, but a federal statute that would enable the federal government to challenge activities that were anti-competitive, that restricted the free market that would otherwise exist in the United States. And of course, as is well known, the United States from the outset always rested on principles of free enterprise and free market competition. And an interesting thing about the U.S. economic system, and in many ways U.S. society generally, was a simultaneous desire for free enterprise, for entrepreneurship, and for business success, along with a skepticism, a concern about significant concentration of wealth. In 1890, in light of the controversy over the Standard Oil, as well as other industries and their practices, the United States Congress passed quickly and almost unanimously what really does stand as the world's first antitrust or competition law, and that is known as the Sherman Act, or the Sherman Antitrust Act of 1890. And it's called the Sherman Act after the name of the United States Senator, Senator John Sherman of Ohio, who introduced the legislation. And that legislation has two basic parts. There are more parts than that, but they're basically two parts that are relevant to this video. Part 1 prohibits every contract, combination, or conspiracy in restraint of trade. And Part 2 prohibits monopolization and attempts to monopolize. And under United States law, there are both civil and criminal penalties for violations of Section 1 and Section 2 of the Sherman Act. And if you've not already read those sections, they're easily accessible on the internet. And I suggest that you take a look at Sections 1 and Section 2 at your convenience. The basic language of those two sections remains as passed in 1890. There began in 1895 a series of cases that the U.S. Supreme Court issued under the Sherman Act, but by far the landmark case that marked the beginning of true antitrust law in the United States, and the case that remains the most famous to this day, came in 1911. And it was the case of the United States versus the Standard Oil Company. As I mentioned, there had been a lot of litigation involving Standard Oil, but this was, and really remains, the major case. And in the 1911 Standard Oil case, the United States Supreme Court unanimously upheld a decision that ordered the breakup of the Standard Oil case. It was a case that applied both Section 1 and Section 2 of the Sherman Act, and ordered that the 40 or so separate companies that made up Standard Oil at the time be broken up from a single entity representing, as I mentioned, about 90% of the oil business into separate companies. And the idea, of course, was to enable, or one could say restore, competition in the oil industry by breaking up these companies. That's the huge, notable, significant effect of the case. But the case also stands to this day for a legal proposition that is very much part of modern U.S. antitrust law. As I mentioned, and as you can read, Section 1 of the Sherman Act says every contract, combination, or conspiracy in restraint of trade. Now, any contract has an effect of restraining trade. If I hire somebody to work on a construction project for 5 years, and that project takes 5% of 100% of his or her time, there is an effect on competition. There is, in a sense, a restraint on competition in the sense that that construction company can't be available for other projects. So the question before the United States Supreme Court was along those lines. When the statute, when Section 1 of the Sherman Act says every contract, combination in restraint of trade, does it literally mean every? In other words, does every mean every? And that was an issue that had been the subject of some discussion in earlier Supreme Court cases, but it was the Standard Oil case in 1911 that answered that question definitively. And by a vote of 8-1, the Supreme Court said every does not mean literally every. Instead, the Supreme Court said that when the Sherman Act talks about contracts in restraint of trade, it means contracts unreasonably in restraint of trade, or contracts that unreasonably restrain trade. And that concept has become known as the rule of reason. And so under United States law, there is the doctrine of the rule of reason. And what the rule of reason says, that if there is a contract, say, between a manufacturer and a customer that governs the territory in which the customer resells the manufacturer's products, the question is whether or not that contract, which restricts the territory of resale, unreasonably restrains trade. That is the rule of reason. So if I make a can of soda in large quantities, and I want my customers for those cans of soda to sell in territories A, B, and C exclusively in order to provide better service to downstream customers, the question is that an unreasonable restraint of trade? So that's the rule of reason, and that's the holding of the 1911 Supreme Court case against Standard Oil, which created the rule of reason. Now, to be clear, in the Standard Oil case, the Supreme Court unanimously found that all of the allegations against Standard Oil, essentially all of them, reflected or were unreasonable restraints of trade. But it did establish this doctrine, or you could say this interpretation of the statute. Now, later, the Supreme Court said that some contracts so obviously unreasonably restrain trade that there's no need for a factual inquiry, that the law irrefutably presumes that the restraint of trade is unreasonable. And that's what's known as the per se rule of liability. And that's a phrase, per se liability, that the Supreme Court first used in 1940. And the classic form of per se liability is an agreement among competitors to fix the price at which they would sell. You could call this a price-fixing agreement or a form of cartel. In any event, the point is that if you have 5 manufacturers of furniture and they all agree in order to, say, increase their profitability, they all agree to raise their prices by a certain amount, under the Sherman Act, that is known as per se unlawful or per se illegal. The point being that it is per se unreasonable and therefore a violation of the Sherman Act. So under the Sherman Act, the key premise is that an unreasonable restraint of trade is unlawful, but the Supreme Court has held, and there's no debate about this, that certain forms of contracts based on extensive prior experience, based on significant experience and economic data, are so likely or so obviously to violate this statutory text, or factually are so obviously going to be unreasonable that there's no need for further inquiry, so they are known as per se unlawful. Now, during the 1940s, 50s, 60s, the Supreme Court identified a fair number of practices as per se unlawful, including various practices that are known as vertical agreements. So in antitrust law, there are 2 basic aspects of agreements known as horizontal, which is an agreement among competitors at the same level of competition, or firms at the same level of competition. So manufacturers A, B, and C who are agreeing on a horizontal level, or wholesalers who are agreeing on a horizontal level. A vertical agreement is one among firms at different levels of competition. So an agreement between a manufacturer and its wholesaler is a vertical agreement. So horizontal, same level of competition; vertical, different levels of competition. And in the 40s, 50s, and 60s, the Supreme Court identified not only horizontal agreements that are per se, but it also identified various vertical agreements as per se unlawful. A major change in U.S. antitrust law occurred in 1977 with a case called GTE Sylvania, involving television sets, and involving in particular agreements between the manufacturer of the televisions and the wholesalers and distributors of the televisions. And in that case, the United States Supreme Court changed a certain type of vertical agreement that restricted the customer and its dealings from per se liability to rule of reason assessment. And this case is incredibly important because the Supreme Court emphasized that per se rules should be limited to certain categories that are highly likely or notoriously likely to be anti-competitive, and that it is important for the Sherman Act's interpretation to avoid degrees of formalism and instead to look at actual market dynamics. And in particular, the court said it's essential to look at whether or not a restriction might not, on balance, be pro-competitive. So, for example, if a manufacturer imposes certain restrictions on its downstream customers, but those restrictions enable, say, better consumer service, as when a seller, a retailer, has an economic incentive to invest in aftermarket service or to invest in the quality of a store, then those restrictions are on balance likely to be pro-competitive, and therefore a per se rule of liability is not in the overall interest of competition or in the overall interest of consumers. Now, a final word on basic concepts under the Sherman Act. The idea of free competition, of vigorous competition, is that when firms compete in the free market, they're likely to price their products lower, they're likely to be innovative, they're likely to provide service to consumers. So, whereas if you have a monopolist, for example, or if you have a cartel, which is an agreement among companies that takes on the economic aspects of a monopolist, you are not likely to promote consumer interests, whereas if you have free, vigorous, aggressive competition, where Company A is trying to win consumers from Company B, consumers will benefit. But U.S. competition law is about free competition. It's about the free market as a system. U.S. antitrust law, the Sherman Act, is not a consumer protection statute as such, nor is it a statute that protects the interests of individual competitors. So if I am a competitor or I am a consumer and I want to bring a private case against a company under the Sherman Act, I have to prove an injury to competition itself. And that can sometimes be a somewhat fuzzy distinction, but as a matter of doctrine, it's one that's quite important and that's quite unambiguous under U.S. antitrust law, under the Sherman Act. Now, since the Sherman Act, since 1890, the United States Supreme Court has developed a large and largely coherent body of antitrust law, and that body of law has been hugely influential outside of the United States, including in creating a body of competition law, or particularly its subset of antitrust law in the European Union. And it's to that topic that I'll now turn in part 2 of this video. After the Second World War, there was an effort among primarily 6 countries: France, Germany, Italy, the Netherlands, Belgium, and Holland, to develop a treaty mechanism that would reduce the likelihood of further conflict in Europe, particularly between France and Germany, and at the same time promote economic welfare and economic development. And that led to a treaty in 1950 called the European Coal and Steel Community. And in that treaty, which fused the economic market for steel and coal among the 6 founding members of that community, again, France, Germany, Italy, and the Benelux, there were 2 provisions that the drafters of the treaty modeled to a degree, I'd say to a large degree, on Sections 1 and 2 of the Sherman Act. And there were several American advisors to the drafters, including experts on U.S. antitrust law, who were heavily involved in drafting those 2 provisions of the treaty, which were Articles 65 and 66 of the Coal and Steel Treaty. More broadly was the effort in 1956 and 55 and 56, culminating in a treaty in March 1957, to take the concepts of the coal and steel community and apply them to the entire economies of those 6 countries. And that, of course, is the Treaty of Rome in 1957. And the Treaty of Rome and its successors are the fundamental documents of what is today the European Union. There are many, many provisions in the current EU treaties, but there remain 2 provisions that are unchanged in their text since 1957. The numbers have changed, but the text is the same. And the current numbers are Articles 101 and 102 of the treaty. Now, Articles 101 and 102 have certain similarities to Sections 1 and 2 of the Sherman Act. Article 101, which again you can easily find on the internet at the EU website if you don't already have it in hard copy, addresses agreements that essentially restrict trade or commerce in the European Union. And this provision, like Section 1 of the Sherman Act, applies to both horizontal agreements and to vertical agreements. It prohibits, most obviously, a price-fixing agreement among manufacturers or among wholesalers, for example, of the sort I mentioned earlier. And it also restricts, I would say, to a greater degree than does Section 1 of the Sherman Act, certain vertical agreements and I'll turn to that in a few minutes. So Article 101 applies to various forms of agreements that restrict, restrain, or distort competition among the member states of the European Union, or member states within the European Union. Now, Article 102 is, again, somewhat similar to, and certainly reminiscent of, Section 2 of the Sherman Act. As a reminder, Section 2 of the Sherman Act prohibits monopolization or attempts to monopolize. Somewhat differently, Article 102 of the European Treaty prohibits the abuse of a dominant position. And abuse of dominant position is a concept that I would say certainly in the terminology and to a degree in its content, a creation of the European Union system of competition law. And I'll describe it in a second. Now, the Sherman Act in the United States is essentially a matter of or form of regulating the marketplace. It is about situations in which there is a significant distortion of competition, or in the terminology one sees in economics, where there is a failure of the marketplace, that it is necessary to have intervention by the government, whether in the form of a court order and a civil action or a criminal action by the government, to restore the conditions of competition. And that aspect of antitrust or competition is certainly part of EU law. But there's another part of EU competition law that doesn't have a companion to it in the Sherman Act. And that is that EU competition law is very much a tool of promoting market integration in the European Union. Now, in 2017, there are many, many aspects of EU law. EU law ranges from the core aspect of establishing the relationship among the member states, the relationship between the member states and the European Union as a supranational body. There are aspects of European law that cover privacy, that cover environmental law, that cover privacy standards, and so on. But all of that rests on one of the founding concepts, which is to integrate economic markets. Because before the treaties came into effect, there were separate markets, by which I mean there were economic barriers, say in the form of import duties or other forms of borders between the countries. So in 1948, there were borders between France and Germany, and a company couldn't simply transfer or export its products between those two countries without going through, say, customs formalities or paying customs duties. And the idea, of course, is that those barriers between the countries would no longer and do no longer exist. And there are many, many mechanisms in the treaties that seek to accomplish that market integration. And one of those mechanisms is, in fact, the set of provisions that constitute EU competition law. And among those provisions are certainly Articles 101 and 102. And as the drafter stated, the idea is that if governments themselves take down the barriers, take down the borders, remove the customs duties, remove the tariffs, It wouldn't accomplish market integration if private entities, if companies engage in practices that essentially have the same effect as customs duties. So, for example, consider the Benelux, Belgium, the Netherlands, and Luxembourg. Imagine a scenario where the customs duties, the tariffs, go away among those three companies, but those three countries, but companies agree that they will divide the territory. So suppose you have companies all making furniture in Belgium, Holland, and Luxembourg, and they say, in the form of a horizontal agreement, well, Company A will only sell its furniture in Belgium, and Company B will only sell its furniture in Holland, and Company C only in Luxembourg. Well, if that were to happen, the benefit of eliminating the tariffs and duties wouldn't exist, because the private companies would be essentially rebuilding or reinstalling the tariffs, the duties, the borders that otherwise went away. So European competition law has a very, very important aspect of market integration, of enabling European integration, or enabling, as people sometimes call it, the European experiment. And that aspect of integration doesn't exist under the Sherman Act. There are provisions of the United States Constitution that say Pennsylvania cannot impose a tariff on goods from New Jersey. So it wasn't necessary for the Sherman Act so much to reinforce those aspects of the U.S. economy. The Sherman Act is really about the private conduct and the market economy. European law is about private conduct and the market economy, but also about reinforcing and enabling European integration, reinforcing and enabling market integration. And perhaps for that reason, for the reason of the link between European competition law and European integration, that the European Court of Justice, broadly speaking, has taken a stricter approach, or in vernacular, has taken a harder line in interpreting Articles 101 and 102 than the Supreme Court has taken with respect to Sherman Act 1 and Sherman Act 2. And by that I mean that the European Court of Justice has been less open to some of the aspects of, say, an economic assessment of business practices than the U.S. Supreme Court. Even though the European Commission has tended to look at things in a way that's fairly receptive to the sort of balancing of pro-competitive and anti-competitive effects that I mentioned in discussing the GTE Sylvania case. Even so, the Court of Justice has tended to apply 101, 102 in a fairly firm way, in a way that some authorities have described as formalistic. Now, I'm not characterizing, in my own opinion, the Court of Justice opinions so much as trying to draw a comparison between the Court of Justice approach and the Supreme Court approach. So let us turn then to a brief look at Article 101 of the Treaty of Rome. Now, Article 101, which, as I mentioned, is worth looking at in its entirety on the internet or in a hard copy, particularly since I'm only going to highlight one or two aspects of it in the brief video today. Is the provision roughly similar to Section 1 of the Sherman Act? It's the provision that addresses agreements, decisions by associations, and concerted practices among what 101 calls undertakings. Now, brief terminology, the word undertaking in Article 101 is essentially, or even synonymous with, a firm or an economic operator. For the sake of simplicity, I'll simply use the word firm or company, because what we're talking about are economic operators. There are, of course, sometimes cases that could arise involving individuals, but it's usually a company or a business. So I'll say firm, company, business. The word in the treaty is undertaking, but I'll use the simpler terms. Now, as I said, and as you can read, Article 101 applies to three types of activities: agreements between firms, decisions by associations, and by associations, the Article 101 concept is an association of companies like a trade association, and third, concerted practices. Now, one of the initial questions in understanding Article 101 is, are those three things, agreements, decisions between associations or by associations, and concerted practices, the same thing? And the answer is no. And I'll focus on the distinction between agreements between undertakings and concerted practices. Now, when Article 101 talks about agreements, it doesn't mean an agreement that's necessarily the same as an agreement under national contract law. Now, national law on what is a contract might have certain formalities that are required. Under Article 101, however, an agreement is something different from, and I would say broader than, a contract, particularly where a national law sets various formalities for a contract. Under Article 101, an agreement can be written, certainly, but it can also be oral. An agreement can be explicit, or it could be implicit. It might be a tacit agreement. So, to take one extreme, if competitors have a written agreement on their selling prices, well, then that is a clear, blatant price-fixing agreement. It's what you could call a cartel, or it's what you could call collusion. And here, again, on terminology, I'll mention the words cartel and collusion are not in Article 101, but they appear often in EU law, including at the Court of Justice level. I'll use them periodically just for that reason, but the words in the article itself are agreement, decision by an association, and concerted practice. So if you have a written agreement among competitors to set prices, it's clearly within the scope of agreement under Article 101. Now, I think it's unusual in 2017 for the enforcement authorities to uncover a written agreement among competitors to set selling prices, but if you think about the possibility of an exchange of emails or other forms of communication that didn't exist in 1957, it is possible to envision an agreement where the evidence of that agreement is some form of written communication, if one is to say that electronic communications are a form of writing, which is a question in a sense almost philosophical, that we don't need to get into here. There are also, of course, agreements on the vertical axis. So if you have an agreement between a manufacturer and a distributor of the manufacturer's products, that agreement often is in writing. And so the question of whether there is or isn't agreement is a relatively easy one. You have a written contract, a distribution agreement, and so there's no real debate. Is there or isn't there an agreement? The question is whether or not it's a lawful or unlawful agreement, as opposed to a situation where there is no evidence of the agreement in a written form, and the challenge is that Company X said to Company Y something, Company Y said something to Company X, and that exchange of oral communication is the evidence of the agreement as such. All right. Now, for purposes of the video, I'll skip over decisions by associations and go to the phrase concerted practices, because the phrase concerted practices has given rise to a fairly large body of jurisprudence and an even larger body of commentary about European competition law. Now, whereas agreement might sometimes be the subject of dispute, of evidence, whether there is in fact, say, an offer and acceptance or whatever would constitute an agreement, the concept of agreement is fairly clear. And under United States law, agreement is the essential requirement to find a violation of Section 1 of the Sherman Act. If there is no agreement, and again, it can be oral or written, explicit or implicit, tacit or not, there must be an agreement without which there is no violation of Section 1 of the Sherman Act. But that is not true, repeat, not true, under Article 101. A few minutes ago, I said a first interpretive question under Article 1 is whether or not agreement and concerted practices are the same thing, and I said no. And here's why that question and that answer are important. Because under Article 101, more precisely, Article 101, Part 1, even absent an agreement under that provision, and parenthetically, absent a decision by an association, there can be a violation if there is what Article 101 calls a, quote, concerted practice, close quote. Now, the phrase concerted practice does not exist in the Sherman Act. It is not a concept under U.S. law that is distinct from agreement. It's a phrase one can find in U.S. law, but again, there must be an agreement. So if a concerted practice is different from agreement, it doesn't establish a Sherman 1 violation. But it does, of course, exist in EU law because it's right there in Article 101, right at the beginning. It's not 100% clear where that phrase originates in the treaty. Unlike, say, a U.S. statute, there isn't a body of legislative history that's readily accessible for the treaty. And to the extent that there is contemporaneous commentary, it points to different elements of national law. But in any event, what matters is that the phrase concerted practice is in the treaty. It is right there in Article 101. And I'll discuss it right now. But before I do, I would simply call your attention to the references in Article 101 to the common market. And those references reinforce the point I made earlier, that Article 101 is very much about supporting integration of markets, about enabling the common market among the member states of the European Union. And even though the designation European Common Market, EC, or EC, it was once called EC, European Common Market, no longer is so prominent. We talk about the European Union. The notion of a common market, a market that is common to the member states, is absolutely 100% still front and center in the EU. So in applying 101, there is always a very keen focus on the relationship between challenged business practices and integration of the markets, or enabling of a common market. Now, what is a concerted practice? The article itself does not provide a definition, nor does it refer to any other source for definition. Instead, the definition has come through jurisprudence. And that definition comes from a landmark case in 1972 by the European Court of Justice that's known as the dye-stuffs case, or ICI for the name of the lead party in the case, Imperial Chemicals Inc., ICI. And it's known as the dye-stuffs case because it was a case involving alleged collusion, to use the general term, among manufacturers of dyes, D-Y-E-S, coloring substances of dyes. So I'll call it the dye-stuffs case or ICI, and you see both in the jurisprudence of the court and in secondary literature. Now, I'll focus only on the holding of the case. You can certainly look at the case at your convenience to see the facts and so on. What's so important about the dye-stuffs case is that it was in that judgment that the Court of Justice defined, and it was up to later courts to refine, the concept or definition, if you will, of a concerted practice. And here are a few points of note. The court made clear that a concerted practice is not identical to, is not the same thing as an agreement. It said it's something else distinct from an agreement. I'll mention that the distinction is often somewhat fuzzy. If you were to draw Venn diagrams or other graphics, there would be a fuzzy border between agreement and concerted practice, but it's absolutely clear from the dye-stuffs case that concerted practice is not the same as an agreement. Instead, according to the Court of Justice, in the dye-stuffs case, a concerted practice is a type of coordination between firms that does not reach the stage or does not reach the level of an agreement and knowingly substitutes practical cooperation for the risks of competition. Now, as is often the case with ECJ judgments, one can isolate maybe the 50 or 100 words of a 300-page judgment that are the key. So in 300 pages, there may be one paragraph or a few paragraphs that are the essence, that are the key points on a legal doctrine, and are therefore relatively brief in space, but have an awful lot packed into them. So unpacking just this first very brief portion of dyestuffs, one sees that we're first talking about a type of coordination, right? So already you can see that when the subject is concerted practices, the focus is not agreement, it's something the court is calling a type of coordination. And coordination is a broader, or you could say looser, or you could say broader and looser concept or scope than agreement. Type of coordination. Second, one reads in dyestuffs that this type of coordination does not reach the stage of an agreement. So here the court is at least implicitly saying there is a hierarchy, or you could say a spectrum, depending on whether you want to look at it vertically or horizontally, it doesn't really matter, but it's saying does not reach the stage of an agreement. So that clearly is saying there is something called a stage of an agreement, i.e. that there must be certain facts present to say the firms, I'll call them the defendants in the case, have reached the stage of an agreement. Or perhaps you could say the level of an agreement. But the court is saying the concerted practice is a type of coordination that hasn't reached that stage. Now, I'll foreshadow a question and an answer. The question is, well, where along the spectrum or the hierarchy is the concerted practice relative to the stage of an agreement? It's very, very difficult to plot it or to say concretely, because it's not 100% clear that all of these facts constitute an agreement, and we could say that's 0.10 on the scale, and these facts constitute the concerted practice, and that's at 0.7 or 0.8 on the scale relative to an agreement. So the court does introduce this notion of not reaching the stage of an agreement, which enables one to infer some form of spectrum or scale, but it's more accurate, I would say, or truer to the jurisprudence to limit that use of stage or reaching to a metaphorical level. So if you will, I will refer to reaching a stage. I'll move my hand one way or the other, but please remember that I'm doing so metaphorically rather than implying some truly quantitative difference. So Part A from dyestuffs, a type of coordination that doesn't reach the level of an agreement. Now, Part A is that type of coordination that doesn't reach the level of an agreement knowingly substitutes practical cooperation for the risks of competition. Okay? So Part A uses the phrase coordination, and then Part B refers to cooperation. All right? And so even if things remain relatively fuzzy at this point, one can, I think, reasonably see where the court is heading or where the court has ended at this stage of its analysis, is that you have agreements. Party A and Party B reach a level of an agreement for purposes of 101, and then the rest of the article kicks in to determine whether or not there is a violation. Now, assume there is no agreement. Assume the enforcement authorities would say there's no agreement. Then the enforcement authorities invoke a concerted practice. They say, we agree there's no agreement, but there is a concerted practice, So we have that element of a violation, and then we'll go on to establish the other elements. So the debate is whether there's a concerted practice. And the defendants say, wait, no further analysis is required because there's no concerted practice. And then the debate will be, is there a type of coordination that's not an agreement that knowingly substitutes practical cooperation for the risks of competition? All right. Then we have some further questions, starting with what are the risks of competition that the court has in mind in the dyestuffs case? Well, one way to look at the risks of competition is to focus on a competitor's uncertainty about what its competitors will or will not do. All right. There are many, many risks of competition. If you're in business, and I'll use again the furniture example, you're in the furniture business and you make furniture out of wood, and there is an infestation in forests, and that infestation kills off a lot of trees, and therefore you have less wood to make furniture. Well, that's a risk of competition relative to people who make furniture out of plastic or metal. Okay? That's not the sort of risk of competition that the court has in mind here. Instead, the court is thinking about, and it says so later, the risks involving or turning on or related to uncertainty. So suppose there are 4 companies that make wooden furniture, and those companies make similar quality, similar priced furniture so that they're competing head to head. All right? And I'm company A, and I would like to be more profitable, so I'm thinking about raising the price of my wooden podiums like this one by 10%. So my podium is now €100, and I'm making profit, but I'd like to make more profit. So I'd like to raise my price 10% to €110. And I believe that it's worth it because of the quality, because of consumer demand, because of my service, and so on. But I'm unsure what my competitors will do. Suppose my competitors are all pricing at about €100, and I go from €100 to €110. Well, the customers might say, wait a minute, I'm no longer going to buy podium brand A, I'm going to buy podium brand B at €100. Otherwise, I have to pay €10 more. Well, the uncertainty that gives rise to the risk of competition for podium company A is what will happen in the market if I, company A, raise my price €10. Will the other companies follow? Will they also raise the price €10? Now, the easiest way, and the most illegal way, to be clear, to avoid that uncertainty is to have a price fixing agreement. Okay, but that is not what we're talking about here. What we're talking about here are concerted practices. And I'm simply describing the risks of competition. Now, what the court is saying is that if through various means that are not an agreement, competitors address the risks of competition, and I've only given one example for the sake of illustration, and there are many others that you could think of. If competitors somehow coordinate in a way that substitutes practical cooperation for the risks of competition, and concerted practices have come up, therefore, in various circumstances, such as announcing in advance pricing or sharing among competitors pricing, again, without agreement, or other forms of information exchange. And it's really in that broad area of information disclosure, information sharing, information exchange, which is reciprocal, that the Court of Justice has looked at the subject of concerted practices. And those cases have concerned any number of different fact patterns, ranging from sharing historical information of market share, to sharing and exchanging future prices, to a one-time disclosure of possible changes in terms of sale, and many, many other variations, from the 1970s all the way to the last few years. And there are probably 20 or so Court of Justice cases that have looked at different fact patterns to, I would say, address, if not clarify, the question of concerted practices. Throughout those cases, a couple principles have held firm and are relatively clear, that each economic operator, as the court sometimes says, or company or firm, must determine independently the policy it intends to adopt on the market. All right? So there's nothing in Article 101 that says every economic entity or every undertaking operating in the common market must determine its business decisions independently. That's something that the Court of Justice has said. And the notion of independence certainly makes sense as a contrary to the clearly prohibited notion of collusion or cartelization. All right? So, in the language of the court, each economic operator must determine independently the policy it intends to adopt on the market. Simple example, I'm manufacturer A of wooden podiums. I'm trying to decide on my future pricing, or less obvious perhaps, I'm trying to decide on my terms of sale. Am I selling net 30 days or am I selling net 60 days? Well, I have to make those decisions independently. And to be clear, by independently, the court is talking about independently really of the competitors. Obviously, I can have an economic consultant or I can ask my lawyer. What it really means is I have to make those decisions independently, right? So if you're thinking of perhaps of a card game, right, where you're trying to decide, do I hold this card or do I toss this card into the pile? Well, I'm not supposed to peek around the corner and look at the cards the other players have, right? It's very roughly similar to that. I'm supposed to make decisions independently of the other players and really the other competitors in the market. Now, does that mean that I have to act with a blindfold? Or, less obviously, if you think of a horse's blinders, do I have to have blinders on so that I can't see left and right? Or does it mean I have to have a blindfold, that I have to just decide, okay, I want it to be 110 euros or I want it to be net 60? Certainly not. Certainly not. And the court has said that competitors, firms, undertakings, economic operators, all the same concept, have a right to adapt intelligently to the existing and anticipated conduct of competitors. All right. So, concerted practices, type of coordination, not an agreement, substitutes collaboration or cooperation for the risks of competition. 2, the risks of competition entail this notion of uncertainty. 3, competitors have to make decisions independently, and I'll add of competitors, then 4 companies have a right intelligently to adapt to the existing and anticipated conduct of their competitors. So when I make a decision, will I go from €100 to €110? Absolutely. I can think about what the competitors will do. And more than just think about, it's not about a crystal ball or a Ouija board. It's about looking at the marketplace, looking at how the competitors operate, understanding them, drawing scenarios and so on to, quote, intelligently adapt to their conduct, close quote. Okay. Now, where is the line between independent decisions and intelligently adapting? Well, for that, you have to go to those 20 or so cases and the hundreds and hundreds of pages of commentary. And I say that not only because this is a short video, but because there is a lot of discussion about those points and a lot of fuzzy areas and, frankly, a lot of philosophical questions. And some of the most interesting discussion comes from somebody who's called Oliver Black, PhD in philosophy and law in the UK, who has looked at these questions very philosophically about what is a concerted practice. And there are many, many examples about how that might or might not play out. If you have 3 people and one of them says, I'm going to go to the movies tonight, and the others hear that, and the others also go to the movies, is there concertation? One of them says, I'm thinking about going to the movies tonight. She goes and the other 2 go. Is there concertation? One of them says, I'm thinking about going to the movies. And another says, I might go as well, but I don't know my schedule. They both end up going. Is there concertation? And on and on and on. And this is an area of EU law that has a lot of these abstract questions that aren't purely interesting from an abstract or theoretical point of view, but really get to these core questions under 101. It's an area where there aren't formulas, where there isn't an arithmetic economic analysis, but where there are these very philosophical questions that are also very, very practical, very significant legal questions. Now, the one other aspect of 101 that I'd like to highlight, and then I'll come back to concerted practices, is that 101 refers to practices that have as their object or effect distorting, restraining, restricting, and so on, competition. And I'll just mention that in Article 101, where it says distort, restrain, etc., those are all synonymous. So you can just say restricting or restraining or distorting competition. But the words object and effect are not synonymous. Very early on, in 1966, in a landmark case called Consten, Consten, the Court of Justice says that or, O-R, means or. Okay? Now, to be hyper-technical, the treaty did not have as an original official language English, but the word or means or in all of the languages of the treaty, okay, which now, of course, does include English. All right, so object or effect. And that distinction has led to many, many interesting cases. Take the simple aspect. You have an agreement that says we are going to fix prices. Well, there you have an agreement. So we're not into this question of concerted practices. And it says we're going to fix prices. So you can say its object is to distort competition. Or suppose you have an agreement where it's not having an explicit object, but economic analysis shows it clearly had the effect of distorting competition. There you have an agreement, the effect of which is to distort competition, and therefore subject to the other aspects of 101, is unlawful. Now suppose you have a concerted practice. So it's not an agreement, and there's no evidence that the parties communicated in a way that reflects a particular object. Or suppose you have a concerted practice where the evidence is clear there was no effect on competition. Right? Take the example of the movie theater. And I say, I'm going to go to the movies tonight. And somebody says, I think I might as well. And a third party says, that's a good idea. Now, suppose that's enough to be concertation. But nobody goes to the movies. So, by analogy, there's no effect on competition. Nonetheless, the Court of Justice might say, well, we have concertation, i.e. disclosure of intent, or sharing of disclosure of intent, all of which relates to going to the movies. So, by analogy to business practices, you could have a restriction or a violation that's a concerted practice by object. And that is another fuzzy area, the subject of different cases, the most recent of which is called carte bancaire, and it comes out of France, and as the name implies, it concerns activities among financial institutions who provide credit cards. And it's a 2014 case that is a very important discussion of what is the word object in the treaty aiming to accomplish, or what is the scope of a violation by object? How loose or broad or how narrow is that concept? And I recommend that case because it explains, at least as of 2014, the concept of a violation by object. And it emphasizes that it's a more restrictive standard than some prior cases, or at least some prior Advocate General opinions had suggested. And there is a 2009 case called T-Mobile involving telephone companies, particularly mobile phone providers in Holland, that arguably is a fairly broad view of concerted practices by object. The carte bancaire case of 2014 seems to be a narrowing of that view. Now, one thing that's clear from all of this discussion of concerted practices and violations by object or effect is that if there's direct or indirect contact among competitors about anything dealing with, say, terms and conditions of sale, that you're already in a danger zone under 101. Right? Now, I'm not saying competitors cannot have interaction. You can have trade associations so long as you honor the antitrust rules. Competitors might talk to each other about matters of legislation. They might cooperate on certain public interest matters and so on. But if competitors have direct or indirect contact, and by indirect I mean through a third party where competitor A communicates to a third party knowing and or intending the information goes to competitor B, and the subjects are, say, selling prices or purchase prices or terms of sale or terms of purchase, then you're already within a danger zone under 101. And then you have to know that if you are influencing competitive conduct, even in a slight way from the eyes of the competitors, as in some of these ECJ cases, there is a danger of a violation of 101. And I say all that as distinct from Sherman 1, where you have this threshold requirement of an agreement and where the court focuses often on the anti-competitive effects. Now, under 101, another thing that's clear is that even if the defendants in an enforcement action can prove there was no effect on competition, that does not necessarily mean there was no violation, because assuming the jurisdictional thresholds are met, there has to be, inter-community trade and so on, but that's a low threshold. If the jurisdictional requirements are met, even with proof of the absence of an effect on competition, there can still be a violation by object. And I would say the overwhelming theme, or the paramount theme, is if there's a concerted practice by object or effect, or an agreement or a decision, that distorts competition in the sense of creating conditions of competition that do not correspond to what the court has called normal conditions of competition, then there is likely to be a violation. The final point to emphasize, I've lost count, but it must be at least the fifth time, and I do that knowingly, is that when the Court of Justice looks at a potential violation, it's going to look at it not only, say, with the perspective of the U.S. Supreme Court and this notion of pro and anti-competitive effects and balancing them. It's going to look at it also with the notion that we in the European Union, we through the treaties, and we as the Court of Justice, as interpreter of the treaty, have the aim of ensuring market integration. And therefore, we will not be tolerant of business practices that interfere with market integration. So yes, says the court, you, the defendants, might be able to come before us with very interesting Supreme Court cases from the United States, along with all sorts of economic evidence and expert testimony from economists. And we understand all of that, but we cannot run the risk of allowing business practices if they're going to interfere with economic integration by distorting competition. And that is a recurrent theme in 50 plus years of Court of Justice jurisprudence under, in particular, Article 101. So before turning to Article 102, I'll just say I suggest that it's worth comparing the language of Section 1 of the Sherman Act with Section 101 of the treaty to see the similarities, but also to tease out the differences, particularly in light of the nature of European integration. The final section of this brief video concerns Article 102 of the treaty. As you know or have heard during this video, Section 2 of the Sherman Act prohibits monopolization and attempts to monopolize. It's very important to keep in mind that the words monopolize and monopolization in Section 2 of the Sherman Act have meanings, or really a singular meaning, that's specific to the Sherman Act. The word monopoly certainly exists in everyday language, at least in English. But the word monopoly itself is not in Section 2 of the Sherman Act. Instead, the words are monopolize, actually attempt to monopolize, and monopolization. And that's because Section 2 of the Sherman Act does not establish a ceiling on the size of a business under the law. It doesn't say if you reach 80% of a market or 90% or even 100%, you're unlawful and the government will break you up. It does not prohibit bigness itself. It does not prohibit bigness as such, even though bigness, the size of Standard Oil, the size of other trusts and cartels in the United States, were clear motivators for the Sherman Act. The Sherman Act is not a law against bigness in business. It's a law against certain types of practices in bigness, certain types of practices that distort or restrict full, fair, and free competition. And one way to think about that is if competition is viewed as competing for something, it's usually competing for market share. Now, of course, there are many measures of business success, profitability, margins, dividends, etc., but a basic measure of competition, i.e. Company A versus Company B versus Company C, is their market power. And a measure of market power, at least in part, is market share. So if we have 3 companies making tables and chairs, and each has 1/3 of the market for tables and chairs, and Company A makes better tables and chairs, and then better, less expensive tables and chairs, and then better, less expensive tables and chairs that are more easily accessible to consumers, and then adds better customer service, etc., etc., Company A is going to go from 1/3 to 1/2 to maybe 3/4, 75% of the market at the expense of companies B and C. Is that something the law prohibits? Absolutely not. That's what the law wants to have happen. The law says when companies are competing, that is good. Good for society, good for consumers. Well, as they're competing better through better products at better prices with better service, better accessibility, etc., they're likely to grow relative to their competitors, which means they're going to get, in simple terms, bigger. So it wouldn't make sense for the law to say, we want you to do all of these things that will get you more and more business at the expense of your competitors, but then we're going to slap you when you reach, say, 70% or 80% or even 90%. All right? Otherwise, there's this basic paradox in play. So the Sherman Act says monopolization and attempts to monopolize. That means doing things that the law would view as anti-competitive by forcing out competitors through certain means or excluding potential competitors through certain means. Now, 102 of the European Treaty does not talk about monopolization. Instead, what it talks about is, quote, abuse of dominance, close quote. It talks about abusing a dominant position with the effect of distorting competition. Abuse of dominant position. All right. So that key phrase, abuse of dominant position, necessarily raises 2 initial or preliminary questions. 1, what is dominance? And 2, what is abuse? I would say that compared to some of the questions that we discussed about concerted practices or differences between object and effect violations, the law in the EU from the ECJ jurisprudence on abuse and dominance is somewhat clearer, although at the end I'll flag some areas that remain for, say, definition by the Court of Justice. Dominance. When is a firm dominant? Well, it's not so much a quantitative test as a test of what is the firm's market power. Now, market power, both in the United States and the European context, is a term that comes up often. And it's important to distinguish market power from market share. Market share is a percentage. It's therefore a fraction with a denominator and a numerator. All right? Now, market share, a percentage, as Company A has 60% of the market for tables and chairs, is highly relevant to market power, but market power is something broader than market share. In a very famous case, the Court of Justice described dominance and market power as essentially the ability to act almost with indifference to what your competitors might or might not do. So when we were talking about Article 101 and concerted practices, I said that the Court of Justice in Dyestuffs said that a concerted practice is a type of coordination, short of a contract or agreement, that substitutes practical cooperation for the risks of competition. And the idea was, I, as competitor A, have a risk in making a pricing decision because I don't know what my competitors might or might not do. So I'm very worried that if I raise the price of my podium 10%, maybe the competitors don't raise prices. I'm therefore at a higher price for equally desirable goods, and consumers will shift to competitor B. Okay? So I am hardly indifferent to what competitors might do. I think about it a lot. It keeps me up at night. And if I am able to sleep at night because of some interaction, some practical cooperation with my competitors, then I'm probably engaging in a concerted practice. So to put it in very, very simple terms, if you'll pardon me for doing so, concerted practices are about being able to sleep at night because of some form of practical cooperation. Now come to Article 102. If I can sleep at night without practical cooperation, if I can make decisions about raising prices, lowering prices, changing terms of sale, expanding distribution, narrowing distribution, changing products, etc., etc. If I can sleep at night relative to competitors, there may be other factors that keep me up, but I can sleep at night relative to what competitors might or might not do in response to my decisions about the marketplace, then I probably have a dominant position. And frankly, the language in the Court of Justice cases has that more or less common sense aspect to it. It basically says, if I can make decisions and act with little regard to what the competitors will do, then I am dominant. Okay. Now, as with the Sherman Act, not prohibiting a certain size of company, Article 102 does not prohibit dominance. There is no law against dominance in the EU. And that's a very important point to keep in mind. There is no rule against dominance. It's a question of how you become dominant and how you act when you are dominant. How you act when you are dominant. So if I have 90% market share and there are other factors that make me dominant, then I have essentially special obligations for my conduct. Or put differently, I have special obligations that if I don't meet them, then I am abusing my dominance. So the law allows dominance. Put oppositely, the law does not prohibit dominance, but the law says if you're dominant, you have to act in a certain way. And I'll give you examples of that in a second. But I just want to flesh out for 2 more minutes assessing dominance. Now, as I mentioned, one very important determination of dominance is market power. Relevant to market power is market share, which is a percentage of a market. And it's very important in assessing the percentage to figure out what the market is, both geographically and in terms of product. And there are many, many cases on this, and it's a very interesting area because it gets into the very dynamic nature of business itself. So if I am making a certain product and I want to figure out in a given geography, what is my share of the market, I have to figure out what are the products that are competing against my product. And here it's a question of what in the law is called definition of the relevant product market. And to paraphrase a famous case from the Court of Justice called United Brands, if I sell oranges and there are 2 orange companies and we each have 50% of the market, do I have a 50% market share? Well, it all depends on what the relevant market is. Arithmetically, of course I do. If I sell half of all oranges, I have a 50% market share. But here's the important point from a legal perspective. It's not an arithmetic question alone, because the question is, are oranges the relevant market? Or do you include apples? And or do you include bananas? So if you add up sales of oranges, apples, and bananas, maybe I only have 10% of all of those products. And again, believe it or not, there was a case that looked exactly at the question of whether oranges, apples, and bananas are part of the same market for a competition law perspective. Okay. And in that case, the court had to assess, key term, the substitutability of apples, bananas, and oranges from a consumer perspective. If I'm a banana consumer most of the time and bananas aren't available, am I going to say, all right, that's not so bad, I can buy apples instead? And if apples aren't available, am I going to say, that's okay, I can buy oranges instead? Where the that's okay is a question of the taste of the fruit, the nutritional value of the fruit, the availability of the fruit, the price of the fruit, etc., all of which rolls into, from the consumer perspective, are those different fruits, the oranges, the apples, and the bananas, substitutable? And in this case, the court essentially said no. And it was a case concerning alleged abuse of dominance by a major banana seller. And the banana seller wanted to say that the relevant product market includes not only bananas, but apples and oranges, and therefore its percentage market share is lower because the total market is bigger, arithmetically. But the court looked at evidence about particular aspects of banana. And here will be my one editorial comment in this entire video. My favorite line from a Court of Justice decision is the United Fruit Brands case, in which the Court of Justice said, quote, "The banana is a privileged fruit," close quote. The banana is a privileged fruit. And what it meant by that is that there are certain aspects of the banana that make it distinct, that make it not so substitutable with the other fruits. So in assessing dominance, which requires looking at market power, which also gets into market share, it's essential to define the market. If you're selling bicycles, is the relevant market bicycles, or does it include also electrical bicycles? Does it also include mopeds and scooters and small cars, etc., etc.? Or is it only bicycles? And of course, that question really is a quantitative one, and my hand gesture implies, are you having X over Y, where Y is small, larger, 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 larger? Because of course, the larger Y is, the smaller the percentage, and the less likely there to be dominance. Dominance also looks at things called barriers to entry. How easy is it? How hard is it for new competitors to come in to the market? So think about things like power plants or railroads. Those are huge infrastructure projects. So if in that context, maybe market share is not as high, but it's very difficult for new companies to come in. All of these inquiries about the dynamic of the market and this question of how indifferent am I to the actions of existing or potential consumers. So if I have 80%, I may not be so indifferent, because if I make a very simple product and I double the price of mine, even though I have 80%, but overnight other competitors can come in and undercut my price, well, it's not so clear that I'm dominant, even though I have a very high market share. And I might, because of that share, be dominant, but I'm not necessarily indifferent, because other companies can jump right in the market. But if I'm making a high technology product that has a lot of intellectual property and I double the price, it's very hard for new companies to come in. All right. So that's what is dominance. How do we know if it exists? So the final topic is, what about abuse of dominance? Well, not everything a dominant company does that a competitor or consumer dislikes is abusive. Not everything a dominant company does that a competitor or consumer dislikes might be abusive. But what are some examples of abuse? Well, one broad category of abuse by a dominant company is a form of conduct that is essentially exploitative, that exploits, say, a customer. So imagine I'm the dominant supplier of wooden podiums, and it's very hard to enter the market for wooden podiums, and I insist that people who want to buy my wooden podiums have to buy my plastic chairs. Now, why is that an issue? Well, I'm 90% of the wooden podium market, and it's very hard for my customers to meet their demands by going elsewhere. And they want my wooden podiums because I make great wooden podiums. But my plastic chairs, they're awful. Nobody wants my plastic chairs. And I have trouble selling my plastic chairs. So what do? Well, I link the plastic chairs to my wooden podiums. And I say, if you want to buy 1,000 wonderful wooden podiums, you have to buy 15, what you would call lousy, plastic chairs. And the customer says, but I don't want your plastic chairs. And I say, well, okay, it's your choice. You don't want the plastic chairs, then don't buy my wooden podiums. And the customer says, but if I don't buy my wooden podiums, I'm not going to be able to meet the demands of my consumers. That is a practice known as tying, T-Y-I-N-G. You're tying one product to another. And in antitrust terminology, the wooden podiums that reflect the dominance are the tying product, and the lousy plastic chairs are the tied product. And if I have a dominant position, the law prohibits that. Now, footnote, suppose I make wooden podiums that are only 5% of the market. And I say, well, if you want my wooden podiums, you also have to buy my plastic chairs. Well, my customer can say, fine, I don't want your wooden podiums or your plastic chairs. I'm going to go elsewhere. I only have 5% of the market for the wooden podiums, so I don't have the market power that makes it an exploitation of my customer. The customer can say, fine, I'll buy the wooden podiums elsewhere. So as an economic matter in the market, I can't force the plastic chairs because the customer can buy the wooden podiums elsewhere. And that's where you see a distinction of what companies can and can't do legally by virtue of their market position. Simply put, tying and other forms of abuse don't work if there isn't the dominance. The dominance is what enables, from an economic perspective, the abuse. Put differently, given the dominance, I have the ability to abuse, and therefore the law imposes these special obligations not to engage in practices that would be an abuse. So that's an example of abusing dominance in a way that's exploitative. Now, suppose I have a dominant position in the wooden podiums, and my wooden podiums are made with a very fine type of walnut wood. And there's not an infinite supply of walnut wood. It's a natural resource. It only grows in certain forests, and only a few companies are able to make it. Now, suppose I go to those companies and I lock up 95% of their sales of walnut. Well, what's the effect of that? Well, the effect of that is it limits the ability to which other companies can compete against me in making and selling walnut podiums. And that has an effect that's known as exclusionary or foreclosing. By locking up an essential raw material, as a dominant supplier, I'm arguably abusing my position because I'm limiting competition. So my customer might not care. So I'm selling my walnut podiums. I'm not tying lousy plastic chairs. My customers don't care immediately. Emphasize immediately. The downstream consumers don't care immediately. They're all getting this podium at a good price for the quality. But I am distorting competition because I'm limiting the extent to which there might be future competitors, for example. And that's a form of exclusion. Now, an area that's very much evolving, where there's a major case pending, awaiting decision by the Court of Justice, concerns discounts and rebates. And again, there's a potential paradox, at least at a theoretical level. So if I'm a dominant player, the law would not want me to charge higher prices because that's a potential, negative effect on consumers. The goal is to give lower prices. So instinctively, if I provide customers a discount on my products, that would not instinctively be an antitrust or competition law concern. But here's how the issues arise. If I have a pricing table that's a straightforward list of quantity discounts. If you buy 100 podiums, it's €100 per podium. If you buy 1,000, it's €90 per podium. If you buy 5,000, it's 70, and so on. All right? That means any customer can come and the pricing is pre-established on a quantitative basis. But suppose I start to apply discounts that say, if you buy so many units during a year, you'll get a rebate. Or if you buy so many units during the year, you will get a discount going forward. Or suppose I say, if you agree to buy podiums only from me, you'll get a discount. It's called an exclusivity arrangement. Well, along that spectrum, there might or might not be a form of abuse of dominance. Most clearly, if I say, if you commit to buy your podiums only from me, you get a discount, well, that has an exclusionary effect. It makes it harder for the other companies to compete because I've locked you up as my customer. But these rebates and loyalty programs and fidelity programs become fuzzier. Even where there's no exclusionary aspect in the form of you will only buy from me, courts have said that the incentive economically only to buy from me might foreclose competition. And some of the cases have become what an advocate general has said are somewhat formalistic. And right now, his opinion, Advocate General Val's opinion, in a case involving Intel, in which he has described the different categories of discounts and the degree of formalism that the court's cases have established, is pending before the Court of Justice, waiting its opinion. And it's possible that the Court of Justice may provide some clarity as to where the line is for dominant companies in providing different discount arrangements to their customers that do or do not constitute an abuse of dominant position. So that's a case to await, the Intel case pending before the Court of Justice. So in summary, on Article 1 of 102, there is no law against abuse. The standard for abuse requires an inquiry into essentially whether or not a company can act with indifference or without regard to competitive reaction. That in turn looks at market power, which consists of barriers to entry and other market dynamics, as well as market share. Market share requires definition of the relevant geographic market and the relevant product market. That's abuse. That's the determination of dominance. Then abuse looks at the extent to which, very broadly stated, there is exploitation of the dominant position, as in tying, or whether there is foreclosure or exclusion of actual or potential competition, as through an exclusive sales arrangement or an exclusive purchase arrangement. And as does Article 101, Article 102 is a very important part of overall market integration within the European Union, as well as maintaining free and vigorous competition within the European Union. So, all the way from the post-Civil War economy to a case awaiting a decision by the Court of Justice on Article 102, I hope that you've found this at least an interesting, quick overview of the origins of antitrust and competition to current pending issues in the European Union under the European treaties and the treatment of free and fair competition. So thank you very much for watching.